So it's my pleasure on behalf of the American Bar Association, the Criminal Justice Section, but certainly the space in which I serve in those capacities, which is the ADR and Restorative Justice Committee, or subcommittee, where I am the co-chair. My name is Talia Gonzalez. I'm a professor at UC Law San Francisco, and it's an absolute delight to be able to host such an esteemed panel of discussants today. You know, the title of this webinar hopefully spoke to you in terms of thinking about what our content is, which is designing restorative justice alternatives, a view from the bench. Please do note this is not a webinar that we are providing CLE credit for, though there are many opportunities through the ABA and the Criminal Justice section where that's possible, including next week at the Criminal Justice section's Fall Institute meeting, and then next year as well. So I'm joined right now by Judge Tim Connors, by Judge Wesley St. Clair, and by Judge Patricia Spratt. We have Justice McCormick Bissig in tech absentia right now. We are hoping in a few moments that she'll be able to join us, but I do want to go ahead and get started. There's sort of three pivot points in which this conversation will evolve. And so you'll sort of hear our different panelists speaking to those, perhaps not all of them, but speaking to some of them, as since we have a more limited time together. And this really is a place where hopefully it's generative to more ideas, to more conversations, and more thinking in particular. One is really centered around this idea of judges and justices as stakeholders in developing restorative processes and restorative systems and practices. The work that we do in the criminal legal system is not something that can happen in isolation. And so how does that sort of evolve both with other system actors, with leaders within an individual jurisdiction? And so we'll get a sensibility as that unfolds, given that everyone is situated somewhere slightly differently. I think it's also important that we can think about observations from the field about whether it's the particularized use of restorative practices or plans to use restorative practices or restorative justice to take us more from the theoretical, which is often the conversation, into the more pragmatic and real. And then, of course, lastly, this sensibility of the salience, right? Like, what does restorative justice and what do alternatives to detention sort of offer in this way of understanding it from the position as a judicial officer, either currently sitting or sitting in the past? So with that, I want to go ahead and I'm going to direct my first question at Judge Spratt and really ask, speaking from your position as a judge and the experience that you've had engaging with restorative justice, sort of one, what brought you sort of into this work, wearing this particular hat, right, as a stakeholder in the system, and why do you think there's a relevance?
The summer of 2008 in Chicago was a really violent summer, certainly not as bad as comparison to these days, but it was the summer that a lot of innocent bystanders in gun warfare were killed, and one of them was a young lady named Hydea Pendleton, who had just come back from participating in the Obama first inaugural celebration in Washington. She was 12 or 13 years old. That broke my heart, and I got to thinking, I don't know how to stop this. I'm just a lawyer and I'm just one person, but there has to be something one person can do. So I started looking around in that Austin neighborhood and found an organization called Build Chicago, which is dedicated to keeping the youth of that neighborhood safe and out of harm's way, out of gun warfare and out of gangs. And I joined the board there, and I work in the public speaking program, and I met some lovely young people there. But while I was there, on one occasion, a dispute arose between two youth who were members of rival gangs. And as soon as that dispute broke out, everything at Build stopped, and immediately they went into a peace circle. I had no familiarity with circles and how effective they are, but I stood there and observed that for 2 hours as it went on. It went deep. The participants really, really opened up about who they are and what they were becoming and why they had this dispute. By the end of that circle, it was about 2 hours. Everybody was in tears, especially the two youth who had started it, and they were in the middle of the room hugging each other. And it just hit me, the power of this kind of process could completely reform the criminal justice system if we could get it into the criminal justice system. And over time, working with a judge in the Circuit Court of Cook County, I wasn't a judge yet, Chief Judge Evans and Judge Patricia Sheehan devised this North Lawndale Restorative Justice Community Court, which has been incredibly successful in the Austin neighborhood. And when she retired, by the time she retired, I was on the bench, and Judge Evans, knowing my interest in this, asked me, would I like to take over the position of judge at the North Lawndale Restorative Justice Court? And I said, absolutely. So that's how I got into it. Now, mind you, I never practiced criminal law. I never sat in a criminal courtroom except for traffic. All new judges go through traffic. So I have no criminal background. My background is just my view that our youth are our most precious, non-renewable resource. And when we lose one to the kind of violence that we lost Hydea Pendleton and all the promise she had, it hurts us all. They're dead. They can't realize their potential, and we can't see how their potential would have grown and blossomed. So the Restorative Justice Court does that. And that's the purpose for my involvement in it. There was a second half to your question.
No, I actually think that you beautifully answered both. And what I appreciate sometimes is we step out of our roles as listeners, as lawyers, and don't just say, part one, I'm going to tell you this in part two. Right. It actually exemplifies the restorative practices that are so prevalent, which is that stories and narrative become essential to understanding, right? Whether we're talking about crime and harm, right? And the individuals that often experience both, whether they're called a victim or offender, that is bidirectional. So I would love to pivot to you, Judge St. Clair, because we've had some time to spend together this summer, in particular at the National Judicial College, where the first course was offered in restorative justice. And so I'm wondering, you came in as someone who was a lead faculty member in teaching that. And so I'm wondering why, why restorative practices? Why are you investing in your time and energy, as everyone, right, on this panel, in creating restorative alternatives to addressing harm and crime?
I've always had a tendency towards helping courts, whether it be domestic violence court or drug court, or even juvenile court. But I was assigned to juvenile court in 2011. And in the course of that, we were in the process of building a new building facility that included a detention facility. And the community activists came to me. I was the lead liaison from the court. The community came to me, asking, why are you locking up our Black and brown children and not providing appropriate services? I joined in the questioning, and in the course of my due diligence, was directed to a community agency that did restorative practice, the circle work, peacemaking circle. So I participated in a couple of peacemaking circles, kind of reluctantly. I said, this is new age woo-woo. I'm not really interested in holding hands and singing Kumbaya, and I sure as heck I'm not going to smoke any marijuana with you guys as we sit in circle. It really became evident to me that this indigenous practice, which has been around for actually thousands of years as a conflict resolution model, was really very, very effective in diverting folk away from our standard punitive model that our criminal legal processes has in place. Very punitive, very retributive, but not terribly healing, not for either the person harmed or the person who did the harm, nor the community as a whole. So after sitting in circle for a while, I decided, this is a better way. I'm not sure it is the only way, but as a alternative to our standard practices, it felt more humanistic. It felt connected. It built relationships and it built trust. So much of of one of the PR issues that the court has is no one trusts it. And the confidence has gone down in the court because of the sense of the bias that is present and the way the court has fed into issues of racism and as we look at mass incarceration. And it's really hasn't been helpful in a number of ways. So is in the course of doing that due diligence, I became a real advocate and took on a leadership role of saying, now, so how do we do this as a community? How do we bring all of the players to the table? And how do we start small? How do we don't want a huge project that actually feeds into failure, but one that actually feeds into success. And so that's how I kind of got into doing the work. And realistically, it has to be our retributive model of response is not really, we call it accountability, but to me, it feels more, accountability is where you learn something from what has occurred, and that you, from that learning process, you now pass that forward to others. And so this felt like a much healthier system.
Thank you. I want to pick up on two themes that each of you talked about and then direct the questions respectively to Judge Connors and to Justice McCormick-Bissig, who, thank you. It's wonderful to now see you. I'm glad technology has worked out. So one theme you both spoke about was the power of process. You had the opportunity to engage in restorative practices, which then really cultivated your desire to be a leader in this space, to use your words. Judge St. Clair, or I will add the word collaborator to what you said, Judge Spratt, because you were talking about Judge Sheehan and Judge Evans. So, Judge Connors, I wonder if you might reflect on either the power of process, meaning sort of seeing this in action, and how that related to your moving into the work around restorative practices in the criminal legal context. Certainly, if there were collaborators, early collaborators, I welcome that too, but kind of thinking about that first question.
Well, thank you. I'll echo what Judge St. Clair and Judge Pratt were saying. And let me go first to the general and then the specific. The purpose of this seminar is really the criminal justice system. That is part of how I came to it. So let me just start with there, and then I'll give you the general background. My wife was an assistant prosecutor in this county for 18 years, and she's one who left prosecution because she felt oftentimes we were not doing justice. And like myself, she embraced peacemaking and has been an active advocate with me. I don't even know where I read this, but it really struck me, and it was a quote from the United States Attorney by the name of Robert Jackson in 1940. I have no idea who this person is, but was an attorney general, 1940, last century. And here's what this attorney general said about prosecution. The qualities of a good prosecutor is one who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches her or his task with humility. That there talks about the values of peacemaking. And like Judge St. Clair, I came and my wife came to understand that with sharing from our indigenous tribal communities and tribal courts, first here in Michigan, across the nation. And people say, when we look at the two worldviews, and as an advocate, I think just as this attorney general spoke out in 1940, I think it is our responsibility as judges We serve the public. We must share with what we see and the ripple effects, and we must advocate for a system that enhances the values that this Attorney General talked about. Those values are in our system already. We just haven't nurtured them. They're in our Declaration of Independence. They're in our oath to take office. Excuse me, oath to become a profession of a lawyer. I administer, I have it right here. They're in our jury system. I just starting my 13th civil jury trial this year alone. I just finished one. And the whole concept of a jury and equality and all voices is already in our system. But we have not nurtured, identified, and advocated for those values. So when we speak of restorative justice and peacemaking, for me, it's already there. It's a question, do we nurture it? Do we support it? Do we advocate it for it? Not necessarily, not as a replacement, because there's times we have to have an adversarial system to make a decision. But it should be a concurrent path available to everyone who wants it in every type of case. And that's what I believe. And so we have brought it to the criminal justice system. We have had effective purposes, but I've learned about peacemaking and we've applied it to everything. I'm in my third decade and third year, 33 years as a judge, and I've tried every kind of case. We've applied it to every kind of case. It's ironic that Justice McCormick here is from Kentucky, because the justice that supported us and allowed this to happen in Michigan was also Justice McCormick. So you got to have the light from above, and then you got to have all the workers that get into the trenches and say, that's fine, everybody, we're just here to do the work. So thank you for asking me that.
No, of course, I appreciate that. And I heard, a couple of themes that built on what we've also had, which is one, this inadequacy of our current systems frameworks, to really align with what you're framing as the responsibility and the values that are already there. And I think that sounds like in many ways what Judge Spratt leaned into in the very beginning, is that our young people are non-renewable resources, and we have to have a sensibility that the system is not actually operating in ways in which it is. And I'm not using the word restorative and restorative justice, but in restorative in the sense of accountability, right? Being able to have those young people or adults be back and part of what our larger polity looks like and what that is. And then to your point, Judge St. Clair, because there has been such a targeting, right, in ways in which the perniciousness of bias has crept into, and our system is deeply not immune from that we have to have an even deeper attention to what disparities look like for our Black and Brown and Indigenous youth and youth at the margin. So with that, Justice McCormick-Bissig, I want to think about some of those themes, but in particular, turn to the twin question of, accountability and your reflections on restorative alternatives, both addressing harm and accountability. Thinking about the work that you shared this summer when we were all together at the National Judicial College, but sort of pivoting along those two lines, if you don't mind.
Sure. Can you all hear me? Am I coming? Okay, great. Good afternoon to everybody. Good afternoon to my fellow colleagues and those I already appreciate those that are taking their time to be on this webinar and learn about restorative justice. Like I just heard Judge Connors say, I have been on the Kentucky Supreme Court only about 8 months now. I come from 21 years as a state trial judge. And I really like that Professor Gonzalez asked me about accountability and looking at that in terms of a restorative justice context. I came from a background where I was a former prosecutor. I prosecuted domestic violence and sexual assault cases. And as I've just told you, a long time judge on the bench. And I went to New Zealand, which was a founder early in the days of restorative justice, where they, through legislation, brought restorative practices, a family group conference circle, to their juvenile crime. And I just happened to be in Mexico working on amending criminal rules and attended an international summit on restorative justice and learned about the amazing things they were able to do in New Zealand, where we're talking about disproportionality and how we have our Black and Brown members of society disproportionately represented in our juvenile courts and in our criminal justice system. And they had a similar core of people called their Maori people who were disproportionately confined. And restorative justice isn't necessarily aimed at disproportionality, but what happens when you have a system that holds someone accountable, and when we say accountable, that they are able to take responsibility for what they've done, make amends, and rejoin community in a larger way, in a way that can take in account a cultural difference, the difference in the lens we all look through, the difference in the life that we all led that led to the moment of someone causing harm and someone being harmed. When the way we address that in our justice system is able to take account of those things as well, then that accountability can be far more meaningful. And in New Zealand, they ultimately, when they legislated that every juvenile case would go through a restorative practice, were able to reduce their crime by a full 2/3. And I'm speaking to you all from Kentucky. We're a fairly red state. And crime and violence are of high concern, as I'm sure they are in many of your communities. But we just can't, as a society, lock away our youth for the next however long and spend whatever it costs in your jurisdiction. And in mine, it's about $42,000 a year, without trying a way to have them have some kind of interface with the person who was harmed, to have a bigger understanding of how what their choices did impacted others. And, you know, we have implemented in our juvenile courts here in Jefferson County, Kentucky, the family group model that we saw in New Zealand. And for me, just hearing the survey results of crime victims, not offenders, but crime victims, feeling much more made whole, feeling like they were a part of the solution. You know, restorative justice is really aimed at victims, but the nice side result is that offenders also have lights come on in a way they don't through our normal crime and justice. You come in, a judge wags their finger, they tell you you violated the law, and you go about serving some time in a juvenile youth detention facility or an adult jail. So accountability is important, and I think it's important for our communities. I just came off before here a meeting where I'm working on some federal grant money to prevent violence, and I suggested using some of the monies toward restorative justice programs. And one of the prosecutors on the call said, my community is so weary of crime, we don't have even time right now to think about forgiveness or trying to forgive someone. And I really didn't have time to correct them. But restorative justice forgiveness is part of what happens when you have a bigger look at the crime. It is certainly one side effect of restorative justice, but I always say the best way to be tough on crime in your community is to put something in place that stops crime from happening. And in our experiences, our youth who go through a restorative practice become much more enlightened about the impact of their crime in a way that locking them away in a jail or having other traditional accountability methods can't. So I've become a big proponent of it. And I hope those of you watching this seminar will think about ways that you could make this a part of your system. I always say it's not meant to replace our long fought due process rights in a court of law. There are people who are not guilty of what they're accused of, certainly, but it's a great tool to further flesh out what we're doing as a justice system.
I really appreciate that. And of course, the academic in me got very excited when you mentioned legislation and when you mentioned outcomes, right? And I think that so often when we're looking at implementing new policies and practices, being able to understand that there is an evidence base for positive outcomes, whether that be decreased recidivism, to put a slightly different way of framing what you were talking about, the positive outcomes for those that experience the harm, right, are victims in that sensibility, both tested here in the US and empirically in other countries where there's more robusticity of practice, but also for the person who caused the harm. And especially when we look at young people, enrollment in school rates, right, graduation rates, and sort of also thinking about how this is upstream, that if we can ultimately diminish system contact, I think each of you, right, would probably agree from your expertise and wisdom that that's essential for lifelong trajectory in a positive way, whether that's health or, you know, the ability to have housing and secure jobs and all of those things that go with it. But I want to come to something that Judge Connors started to open the doorway with us, and you did too, Justice McCormick-Bissig, which is this idea of implementation. Well, so what does this look like on the ground? You know, I've heard circle practice, I've heard family group conferencing, but so often I think people will hear the lofty, they might hear the values, they might think of forgiveness, accountability, but then when you're trying to do this work in the weeds, shall we say, right, in the more structural, that can be really hard. So I have two questions, and please decide which one seems most appropriate for you to answer at this time. One is a reflection on how judges are key stakeholders in that design, right? Sort of what is the role that judges and judicial officers can uniquely play in designing and implementing restorative systems, right? Restorative practices and processes. Another question, right? And please, it's a choose your own adventure pathway, is about what does this look like in your jurisdiction? I mean, we are hearing, you know, from Michigan, Washington, Illinois, and Kentucky. So do you have observations about what the work is like on the ground? So either of those sort of opened up in that context as you think is most appropriate to be reflective on. And I'll start with you, Judge St. Clair, and then I will actually ask you in a traditional restorative style to pass it to the next person after that.
And Ms. Gonzalez, Judge St. Clair, my hero, I'm getting a my work tech computer saying your computer's about to restart and I may get logged out. So I'm glad my leader there is starting. If I disappear, it's not intentionally. I'll be back.
Okay.
Wonderful. Thank you for letting us know, Judge.
So I'll wait, make sure that it passes to you later, Judge Connors. You know, judges are a key stakeholder because, I don't want judges to be circle keepers. They don't need to have that expertise. What I think judges need to do is to allow for convening, use the black robe to convene people together, your local experts, because there are experts in just about every community that is doing this type of work, and to make space for them to appear. And to convene the prosecutor, the defenders, your probation department, your community-based providers, your social workers, all the jail, you know, your detention facility, all those players come to the table, and for you as a leader to make space for the conversation to take place, to be able to not foreclose people from having the conversation, but to encourage it, and to look for opportunities within your calendar to say, you know, in King County, where I'm from, in Seattle, Washington, we had as everywhere has, we're having enormous gun violence issues, and oftentimes we would have, we had a young offenders program for gun offenders, and they would sit in circle for 6 to 9 months, and in the course of that, everyone's participation, the community's participation, prosecutorial folk, defenders, all got a deeper understanding of the importance of restorative practices, not only within the context of the criminal, but in the civil and just in the community as a whole. You know, many of schools are now actively engaging in restorative practices as a alternative to a disciplinary model that used to be based upon zero tolerance. And so I always encourage people, go where it's open, where there's a willingness to go there, where the opportunity presents itself, and then use the power of the robe to bring people together. In the course of bringing people together and making space, because just because you're the leader doesn't mean you need to do all of the talking. The power of peacemaking circles is it's about listening. And it is the more you listen, not to respond, but listen to understand, then the greater is the opportunity for your ability to see those collective opportunities kind of present themselves. I'll pass it to Justice McCormick-Bissett.
All right, thank you, Judge St. Clair. I would add a couple of things. I would echo what he said, and just getting really practical. He's right. If you are on this call and you're a judge and you're interested in and maybe starting some restorative program in your jurisdiction, if the judge calls your state's attorney, calls your district attorney, calls your police department, calls your local faith community, calls social work agencies. What we did when we started restorative justice was really get a huge oblong table with all of the partners in our justice system, our clerks, our public defenders, our prosecutors, the police department. And judges are probably the best or the most effective at sending out those emails and getting that group to meet. We want to meet and talk about something we could bring to our jurisdiction that will add to our ability to address crime. And to have a meeting where you talk about what is restorative justice, what kinds of practices are out there, what makes sense to implement, at what point you want to put it into your criminal justice process. Do you want to do it pre-adjudication? Do you want to do it post-adjudication? But the judge really has the ability to carry that torch. If you're on this call, though, and we have Commonwealth's attorneys, but if you're a district attorney or you're a chief public defender or you're someone else in the system, you can still carry the torch for this work. And I would recommend really getting people from the different elements of your justice system together and around a table and planning. What could you do? What resources do you have in your community? What system partners would be open to trying something different? For a long time, we had a head Commonwealth attorney who, again, is our district attorney, and our state police commissioner wouldn't meet with me about restorative justice, said he wasn't interested in it, wasn't interested in something soft on crime. And, a lot of times it takes pushing, it takes showing them data of where it can be effective and how it can be effective. But I just think it's important that somebody take the idea and get others talking about it. And there's some great resources. Some of them we watched when we were gathered in Seattle this summer, videos and different resources that can quickly try to explain to people who are new to restorative justice what it is and the goals. We saw an excellent video this summer. There's a book by Howard Zare called The Little Book of Restorative Justice that's quick and easy to give people. But regardless of who you are in this call, I would say if you have an interest in this, even reach out to some programs in the country that are already ongoing and see what kind of practices people are doing. But to me, it really starts with getting all the partners that come together to get a case through our what I'll call regular justice system track, and see if they're open to discussing where, when, and how you could add a restorative component. You can do it for certain types of charges. You could do it on certain court dockets. If you have a judge that's willing, we started in juvenile court just because we thought our community would be more able to accept this new idea with youth rather than adults. And we're trying to baby step our way into adult court, and it isn't easy, but we're working on it. So I hope that helps. And I'll pass the torch then on to Judge Spratt.
So in Chicago, the process started exactly as Justice Bissig described, as a grassroots process, starting with Judge Sheehan. She was assigned to the juvenile court division, and she had begun having practices after court, and having circles after court with juvenile offenders and the arresting officers. And the power of those circles, she said, I never witnessed any of it, but she just said it was a surprise to her. The transformation of both of the participants, or the both of the members of the circle who were the target of the circle. And again, circles took about 2 hours. And at the end, everybody was hugging and crying. And to understand that a police officer who makes arrests every day understood what was going on in the life of the participant when he was engaging in that criminal conduct, and for the offender to understand what was going on in the police officer's head at that same time, and what their different responsibilities were, but the humanity of both of them was just incredible. And that's how she got in touch with, knowing that there was a hub in North Lawndale that provided services to youth who came through the North Lawndale Christian Legal Center. They were able to get stakeholders in the community and in the various agencies, from the court, the public defender, the state's attorney, the court clerk, the social services. All of these stakeholders held many conferences and discussions in the North Lawndale area to garner support from the people who live there. And they got a lot of support. And the first court opened up in 2017. That was the North Lawndale court. Avondale and Englewood opened up it's a little more than 2 years ago. And the result of what's happened with this court in the North Lawndale, mind you, there's 77 distinct neighborhoods in the city of Chicago, and every one of them wants a restorative justice court. And I would like to see that happen. It's a different model that we use from that which is used in New York, the Red Hook model, which is completely court supported. But it's a model that works. And to explain, I've heard the same thing you've heard, Judge St. Clair, that this is some woo-woo type of court, and that it's all touchy-feely and doesn't result in any good results. I can tell you, academically, that's wrong. First off, the Chicago Sun-Times of July 15th, 2022 reported that the number of arrests in North Lawndale has fallen by nearly half from pre-pandemic levels. Now, North Lawndale remains a very gun-ridden and violence-ridden neighborhood, but to that have fallen in half, I will say with some pride that I believe the North Lawndale Community Court, Restorative Justice Court, can take credit for some amount of that. I can't tell you how much amount, but the proof of that is we had a professor, Dr. Tom Lyons, do a study on the efficacy of the 3 courts for the years 2020 through 2022. And in those years, 218 youth had come through the restorative justice courts in those 3 neighborhoods. And 1 year after their graduation from the court, the recidivist rate was just 16%. The recidivist rate for similar offenders charged with similar crimes and with similar characteristics, but from neighborhoods that do not have restorative justice courts, was 65%. So we save lives, we reduce crime. And when that happens, when crime in a neighborhood is reduced, businesses come back. And when businesses come back, jobs come back. And when jobs come back, people are working and they're not out on the streets selling drugs and having gunfights. And when that happens, people in the neighborhood can sit on their front porch talking to neighbors, enjoying some lemonade on a Sunday afternoon, watching their children play hopscotch or jacks or pickup sticks on the sidewalk. So the neighborhood then blossoms. And that is exactly what is happening slowly. But that's what's happening in North Lawndale. So to anybody who thinks this is not effective, I say humbug. Now, one of the things that our legislature did to promote the efficacy of the circle process was to enact a law that holds confident or conversations in a restorative process. And for us, that's when the participant is talking to the representative from the social services department who does an ORAS assessment of their needs, when the participant is talking to their circle keepers in pre-circle or in circle. Those conversations are privileged, and we make sure they understand nothing they say in those conversations will ever come back and bite them in the rear end. And generally, I don't think it happens all the time, but generally those conversations, when the participant loses some of their layers of emotional body armor they're wrapped up in, and they begin to let people see who they really are inside, in some of those conversations, they actually confess to having done other crimes for which they were not arrested. Now, they would not have done that had they not had that privilege. So there would have been some barrier to them being completely candid with their circle keepers and with the with Mr. Young, who does the ORAS assessment. So the way we've done it in Illinois has, in those 3 neighborhoods, mind you, we've got 74 other neighborhoods who want it and suburban areas who want it. And once we convince them how much money this saves, Justice Bissink mentioned how much we pay to incarcerate. The county will save a lot of money and can divert that money to the restorative processes. I'm on a crusade to convince our county superintendents to give us more money for more courts. And I often refer to how successful the New Zealand juvenile courts have been, which I would love to visit. So I'll pass it off to Judge Connors.
Thanks, Judge Spratt. You're absolutely right. You said at the beginning that, I mean, to even begin to talk about restorative justice in an hour is just scratching a fingernail and scratching the fingernail of a newborn baby in the little finger. But be that as it may, I think I'd like to go from the general to the specific, how it looks on the ground, because I think when we talk about what we're doing on the ground, it has to be how we're trying to implement what we believe in. And it seems to me as judges and as attorneys, we have this responsibility. We look at whatever kind of case comes into our court system. They come through our doors because they're in conflict and they can't resolve it outside of our court. Conflict comes from chaos. It's the argument that we have competing concerns, we can't agree, and each side is trying to preempt or displace somebody else's argument. So this concept of rights that we have that bring the ability to articulate this conflict in our courts, we start there. What is our responsibility? We need to think about first, what's the ripple effect of this conflict? Who's affected by it? The community that's affected by it. The people that follow are affected by it. So we start with that ripple effect, and as we look at that ripple effect, we start to analyze relationships. How are all these entities and people who are affected by this ripple effect connected? So now our responsibility, it seems to me, no matter what the conflict is, we have a responsibility to bring calm, to not exacerbate conflict, to not make it worse, to say we are here to heal. How do we bring calm? It's through the creative aspect, to pick up pieces and rebuild. So I think if we start with that basic litmus test coming in and look at whatever kind of case comes in, then our procedures, how it looks on the ground, how we fashion it for that particular conflict is the creative process. And that frees us up. I don't think the only thing I would disagree with on what Judge St. Clair has told me earlier is I don't think that judges should not sit in circle. I agree with all of us that if you have to fulfill your role as ultimately the decision maker under a conflict and create a record, you should not be the judge in circle. But I think as judges, it would behoove us to become better judges if we do sit in circles for maybe another judge or something like that. And I see Judge St. Clair nodding his head, and I know Judge Spratt, you saw the power of that circle, and I know Justice McCormick saw the power of that over in New Zealand. So how that, when we take that big part, that's the main thing. Then if we're going to bring calm and how we're going to be creative, let's look at that. And again, it's voluntary. We're not imposing this on anybody. We're saying we already have a system in place. You don't have to do it. We're offering this. If not, then we'll go do that job. And what do we end up doing? As judges, we simply label it, process it, close it out, send it back out. That's why I say we must have a, what I call not alternative dispute, but preferred dispute resolution, or PDR. So that's sort of, believe me, I could get into statistics, on the ground. We literally have done it with every kind of case. We've been doing it over a decade.
Thank you, everyone, for reflecting in that way. I'm attentive to our final 9 minutes. I've noticed that we don't have questions in the Q&A, so I'll take liberty to ask another question to each of you. But first, I do want to acknowledge that, legislation has come up a few times, and in particular, Judge Spratt just reminded us about the importance of legislation relative to confidentiality and admissibility. I think that if we're talking about this being implemented, that still, though, outside of Illinois is a woefully under examined and underattended area. There are less than 15 states across the country that have even passed or considered this form of legislation. Some have been unsuccessful over periods of time, and some don't actually put in place the robusticity that Judge Spratt was looking to. So, as stakeholders, whether, you're joining us as a judicial officer, or you're joining us as, a prosecutor or a defense attorney or someone else in that context, starting to think about what the legal infrastructure is. That also ties to Justice McCormick-Bissex's point in that when we ask the where, when, how, in some states, our legislatures have told us that where, this can exist, at what time, and have even built some of that infrastructure up. And so the ability to activate that thinking that's already occurred from that bigger ecosystem approach that each of you have identified in terms of what it means to bring folks to the metaphorical and literal table to have these conversations. So I do want to remind us, that we are close to 275 laws within the criminal legal system alone that are specific to restorative justice, operating in both juvenile and adult contexts across that continuum, and even actually outside of the continuum as we might move into the formal adjudication moment, and even impacting our officers on the ground, and what the possibilities look like. So Colorado being an example where, in the field, officers can make determinations to not arrest and ultimately defer to a restorative process. So what is it to, think about, Judge Connor's point, which is to elevate what we already know, right? What's already in existence, whether it's our values or our infrastructures. So, oh, sure. Now all of a sudden 4 questions pop up in the chat at 6 minutes left. I love my invocation led to positive activity. So I am going to quickly look across these. So I have I'm going to consolidate 2 together. So one is asking about sort of scope of harms where it's been used effectively, and then coupled with that is a query about has it been used in sexual assault cases? I would perhaps extend that to sexual harm, sexual violence, domestic violence. So anyone interested in answering this question of scope of harm, where you see it operating in different contexts?
Certainly New Zealand uses it in every single type of case that occurs, including murder, rape, robbery, assault. The fact is it's a victim-centered process. And even though, there's going to be punishment in all of those cases, but there's a healing process that elevates the voice of the person harmed to one that is acknowledged by the system. Because in our traditional system, those persons harmed seem to be used as just a vehicle to get this outcome. But then there's no healing that occurs. Their voice is not really heard in the process. But I've seen it used in those wide variety of cases, both as the person harmed and the person having done the harm. We've had people present to the National Judicial College, those who recently released folk for murder, and there was a reconciliation with. Sometimes it's surrogacy reconciliation. It's not directly, but it's other people coming in. But also there's been face-to-face reconciliation that has been shown to be terribly healing for both sides.
Excellent. So one other question was, what does the public need to see to accept restorative justice measures? I think Justice McCormick-Bissig, you noted this around the political landscape in Kentucky, but I just wonder your thoughts more generally of what you've seen as successful in moving restorative justice measures forward in Kentucky, and then I'll invite anyone else who wants to remark on that as well.
Sure. And I agree with what Judge St. Clair just said about the scope. We started, just so you know, we started small. We had low-level assaults, thefts, damage to property, but restorative justice principles can be profoundly impactful even on more serious crimes up to murder. In terms of, and I think this question, Professor Gonzalez, is so important, because when people are harmed, they become scared. When the community sees people harmed, they become frightened. I don't think people are bad people, but I think frightened people don't always react to things in the best way. And just like I was saying on my call earlier, it can be a tough sell. When you mention restorative justice, people think compassion, people think forgiveness, people think kumbaya in a circle. And I think it's our job as people committed to the justice system to try to make sure that that's not the rap. It's not that restorative justice doesn't do those things. It does. But I think it's important. And one of the things I like about being a judge is that I'm not a Democrat or a Republican. I am just someone who's trying to do the right thing in my community. And I like it that it can be a position embraced by both sides of the aisle. You know, for people that are more conservative, when you talk about doing something that's effective, the numbers that Judge Spratt just talked about in their one community in Chicago, and we have similar statistics from our exit surveys of youth who've been through this process not reoffending. So lowering recidivism rates is something that can be seen as an approach to deal with crime, not to excuse crime, but to take it head on. And then, of course, for people who tend to be more left-leaning, or what we would say Democrat, then the ideals of reintegrating someone into community, not labeling them forever a criminal where they can't participate and hold a job and support their families. So it's something that's family-centric. It's something that is another tool for our prosecutors and defense counsel to be able to effectively deal with crime. And I think it's really important when you go places to talk about this, that you kind of start there. When you say, oh, I want to tear down the system and bring this in, people shut down. But when you really talk about the solid gains you can make and working with all of your criminal population, that's a bad way to put it, but with people that create harm and doing something other than just locking them away and then labeling them a criminal when they come out and they don't have a way to reintegrate in society, I think this can be really effective. And I would just encourage people to be aware of their language when they talk about it to people who haven't seen the magic of a conference or seen the healing that can occur, because what they want to hear is that we're dealing with crime in our communities.
And I'll say this about Chicago, come and watch. We have open court sessions every Thursday at the UCAN Center in Chicago. Now, if you're in Chicago, that's easy enough for you to get to. If you can't get there, I use a hybrid model. I allow participants who cannot make it to the courtroom at the UCAN Center because they have a job or because they're in school or they have childcare issues or they're on electronic monitoring or they can't cross certain boundaries because they're gang affiliated. So they can Zoom in. And those who are sitting in the courtroom have the ability to watch it live, and those who are on Zoom can watch it through Zoom. It's very simple. See it in action. And one of the final effects that I forgot to mention about what happens when crime is reduced in a neighborhood, how people come out and they are not so traumatized and sit on their front porch. The other thing that happens is because there's less crime, you have fewer police in the neighborhood. So that's an organic way to achieve the result you want to achieve from defunding the police. Just get them out of the neighborhood because there isn't so much crime. That's another result.
Thank you so much to everyone. I'm just acknowledging that we're at time or a minute over. I've been trying to respond to some of the questions in the Q&A. Also, I wasn't just, generally texting or writing a grocery list there. If you saw my attention being a bit more towards my computer and my keyboard. So I want to reflect on the three final things that are in there, which is one, there is strong interest in accessing the Zoom link. Judge Spratt is responding to that independently so that people can see that. And that also we had a comment from Judith Stewart, who was just acknowledging the power of doing the work, and that in fact there was the first teen court peer accountability circle held last night, and the ways in that it went and the positive outcomes, and that to put a underscore under trauma and the ways in which that also matters. So I want to thank everyone for joining us this afternoon. I have put my email address in the Q&A so that if anyone wants to access it, but I'm also quite easy to find if you Google Talia Gonzalez, because I'm happy to provide some of the resources that were asked for in that context. And I imagine, right, in each of your jurisdictions, there's many resources available as well. And hopefully people can begin to see those possibilities as well as perhaps observe. So with that, I want to thank everyone again for joining us. This was a fantastic conversation. I underscore it is the tip of a pinky finger scratching of a young person. I have a soon-to-be 7-year-old, so her fingernails are also quite still small, though not a newborn, and that, we really are asking the question that it was framed as the title. Designing restorative alternatives. What is that view? Here, our view was from the bench. We've thought in previous webinars, the view from the academic perspective, the view from those that are working in the field, either in defense or in prosecution or as practitioners. So hopefully this helps build out a bit more of a comprehensive compendium. And then I will, for my last moment, say that if you're continuing to be interested in this conversation, next week is the ABA's Criminal Justice Section's Annual Institute, and there will be one of the two main panels on restorative justice. So please do look for that if you happen to be in the DC area or if you're able to Zoom in and provide and get that information. So with that, thank you to everyone, to Judge Connors, to Judge Spratt, to Justice McCormick-Bissig, and to St. Clair. And I think Judge Spratt wanted to add one last thing.
I do. I'm getting requests for my how to get into the Zoom. I'll just throw out my email address and send me an email and I can send you the Zoom link. My email address is patricia.spratt@cookcounty.gov. Common spelling Patricia, Spratt with 2 T's at the end.
Thank you so much for that generosity, Judge Spratt, in sharing that. And with that, we'll go ahead and sign off. And so whether you joined us live or you're watching this at a future date, it's been a great conversation, and I hope it sparks some critical thinking and possibilities in your own jurisdictions. Take care.
Thanks, Professor. Thanks, judges.
Good to see you all.